Good morning, everybody. Happy Tuesday. Welcome to TCF Live. My name is Dan Soul. I will guide you through this 3-hour journey through Courtlandia. As is typical when we come out of a holiday weekend, a slow start out there, but Judge McNally's got some stuff going, so let's start with him.
Game violation. They think that you possessed bass during the catch and immediate release season. You have the right to a lawyer. I'll be happy to provide you with one now at public expense if you would like one. Would you like an attorney to represent you? Do you have any questions for me?
Well, I don't know if I need a lawyer, do I?
It's up to you.
Well,
I can either give you a lawyer or I can explain the possible penalties, go over your rights with you, and send you and the interpreter to the prosecutor to discuss the case.
maybe the second option, you said you can explain to me.
Sure. This charge is punishable by up to $100 in fines. And these are the maximums, okay? Up to 90 days jail, court costs, or all of those. Do you understand that?
Yes.
I want you to also understand that I'm not saying, I don't want to know, but if you plead guilty, there could be immigration consequences to this. And I don't want to know anything about your status, but I want you to understand that. Do you understand that?
Yes.
Do you understand all of your rights on this advice of rights form?
Yes.
You've read them and understand them?
Yes.
If you plead guilty at any time, you'll be giving up all those rights and we will not have a trial. Do you understand that?
So can I just pay like a ticket or something?
Well, that's up to the prosecutor. She might just reduce this to a civil infraction. I don't know if she will or not. I can tell you this. If you're not legalized right now, I would definitely get a lawyer. And I can give you one now. Do you understand that?
Then it's better than for me to just go ahead and have a lawyer.
I'm gonna enter an not guilty plea, $100 personal bond. Here are your bond conditions. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed.
So if I have that lawyer today, then do I have to come back for another court date?
No, you're gonna see if you can resolve it. We're gonna give you the lawyer and follow his or her direction, okay?
Okay.
All right. Good luck. We'll see you back here in a few minutes.
Maybe you to sign. Switch your.
Lisa, can you hear me?
Hear you?
Okay. I'm signing this order.
For the adjournment,
Yeah, but I
Miss
want you
Cahalan.
to,
Miss Cahalan is on because she sent it over the weekend, so she just wanted to be sure.
yeah, let's call her on here.
She's on there.
I'm here, Your Honor.
Ms. Cahalan, I want you to, listen, I'm gonna sign this order, but I want you two to get together and give us a date as soon as you can. I I don't like putting these off this much. I get it. I'll do it. But you guys got to come up with a date. I don't want my judicial clerk sending out June 26th or whatever day and then having people say, well, I can't do it until July. So would
Judge,
you
I
get
think there's a
with Mr.
date on there.
There is a date on there, Your Honor.
There is?
Yeah, we sent it out.
Be adjourned to June 23rd or a time thereafter. Is Mr. Dox available on the 23rd?
Yeah, he's the one that suggested the 23rd, and that date works for me as well.
Okay. Just set the time with that, Lisa, and we're good. I've
Okay.
signed it. And you can get a hold of Mr. Dox and tell him I signed it, somebody, if you would, please. Okay?
I will. Thank you, Your Honor.
Thank you. Have a good day.
You
Thanks.
too.
All right, Mindy Malmston. File 25B722119. Good morning. Your name? So I've read your motion here. I'm going to allow you to leave the state between June 4 and June 15. I need you to talk to somebody. Listen, you're on probation. As an example, people who get a drunk driving can never go to Canada. Okay? So I'm going to let you leave the state, but it's up to you to confirm with federal authorities that you're not going to have any issues getting there or coming back. Do you understand what I'm telling you? So I'll let you leave the state between June 4 and June 13, 26, but just so we're clear. Yes, go to the defense lawyer with the interpreter. Maybe they can just jump in. Do you understand what I'm saying?
Yeah.
So you check with federal authorities and you make sure you're good. I'm signing the order. You can leave the state between those days. I'm not saying you can go to Mexico because I'm not going to bear that responsibility. You got it? Okay? Do you understand?
So you're saying that
I would check with immigration officials and make sure that there's not going to be a problem. Tell them you're on border security. I don't know who you would go, to be honest with you. Who do you think, John?
I don't know, I'd probably call the US Customs downtown, talk to them.
And you got to make sure that you just tell them, I'm on probation for domestic violence. I want to go to Mexico. Is there going to be a problem?
Okay.
Okay?
Okay.
All right. Otherwise, I'm signing the order. Good luck. Thank you. Jesse Gannon. Jesse James Gannon. 25F722969.
Judge, we're still waiting for the attorney to log in. That's set for 9.
From Ms. Belcher?
Yep.
Okay, no problem. Did each of the two of you check in with my court officer? Yes?
I did, but my name is with Essen. She's not here this morning, so I went to the ladies of the glass.
Okay,
Miss Belcher's here now.
okay,
My case to send it down here.
okay. Jesse James Gannon, 25F722969. Well, Ms. Belcher, good morning to you.
Good morning, Your Honor.
How are you?
I'm well. How are you?
Good. It's good to see a lawyer showing up on time.
I try.
All right, so we're just adjourning this?
That is correct, Your Honor. We are still awaiting a report from the Forensic Center.
Do you have any idea when it's scheduled?
Your Honor, the last correspondence I received from them indicated it would take additional 6 to 8 weeks to do the report. I think we're getting past that. I think the issue with Mr. Gannon is that they were seeking a number of different records from different medical facilities. So that could be
Okay.
causing the delay.
How many weeks do you think I need to set this out?
I would say maybe a month, Your Honor, and if we get the report back before, we can always have a hearing within 5 days of having the report.
Exactly. Let's set it for June 23rd. How's that, Lisa? Is that good?
Yes, that's fine. 9
We'll
o'clock.
do it At 9 o'clock, okay?
Thank you, Your Honor.
Have a great day. Thank you.
You too.
All right. I didn't follow in Mr. Gannon. Mr. Gannon, can you start your video? Or he didn't?
Yeah, he was in there, Judge. He just didn't start his video.
Right, is he, can? All right. That's just all nobody, so. Mr. Gannon, I just adjourned your case until June 23rd at 9 o'clock in the morning, okay? You gotta just start your video if you can, unmute. You started your video, but unmute. All right, I'm gonna let it go. I can see you. You can hear me, right? If you can, give me a
Yes,
thumbs
Your
up.
Honor.
Okay,
Yes,
now
Your
I can hear you. So we adjourn your case until June the 23rd at 9 o'clock, pending the results of the receipt of the forensic report, okay?
Okay, thank you, Your Honor.
Have a good day. Good luck.
You too, thanks.
Let me see the docket.
Good morning once again, everybody. It's TCF Live on a Tuesday. I wanted to say Monday right there, as you always do when you come out of a holiday weekend like this. But episode 297 today. Episode 300 will be on Friday. Time marches on here, doesn't it? Let's move along because he's still trying to sort out what's coming next. Let's go to Conneaut, Ohio. Say good morning there.
The police released her and gave her personal recognizance bond and with an order that a summons that she appeared today for her initial appearance hearing. Since that time, a criminal charge has been filed against her. Ms. Patton is present without counsel. Ms. Patton, have you received a copy of the complaint or charge filed against you?
I have the copy that I got released with.
Okay, here it is. I'm sorry. Here's your copy. Okay, you are charged with one count of disorderly conduct. So I'm going to read you your rights. So please pay attention to the rights I'm about to read to you. You do have a right to be informed of and to understand the nature and the elements of the charge filed against you. You also have a right to know the potential penalties that could be imposed. You are charged with one count of disorderly conduct. In your case, we typically call this charge aggravated disorderly conduct. It is a fourth-degree misdemeanor. It's punishable by maximum 30 days in jail and a maximum fine of $250 plus court costs. Do you understand the maximum potential penalties?
I do.
You have a right to remain silent and not to say anything during this hearing that might incriminate yourself. Any statement you make could be used against you. You also have a right to a trial to the court. Because you are charged with an offense that carries a possible jail sentence, you also have a right to a jury trial, provided that you timely file with the court a written demand for a jury trial. At trial, you have the right to confront and ask questions of any witness who would testify against you. You also have a right to use the court process to secure the attendance of any witness who you would want to testify on your behalf. At trial, you have the right to be proven guilty beyond a reasonable doubt and a right not to testify. You also have a right to have an attorney represent you in your case. And because you are charged with an offense that carries a possible jail sentence, you also have a right to court-appointed counsel and to have a lawyer assigned to represent you only if you cannot afford one. If you do qualify for court-appointed counsel, there is a $25 application fee and a $50 cost reimbursement assessment that apply. You also have a right to a continuance of this initial appearance hearing in order to retain the services of your own attorney or to consult with your own lawyer. If you are convicted of this charge or any related offense, you have a right to appeal the conviction or sentence. That must be done within 30 days of the conviction, and you would be entitled to a court-appointed attorney in the Court of Appeals if you receive a jail sentence and cannot afford a lawyer. Now, if you plead not guilty today to this charge, I will set your case for further proceedings after today, and I will set a bond. The bond is set by the court to ensure your appearance at all future proceedings as well as to protect public safety. And today you have the right to a reasonable bond. If you are not a citizen of the United States, you're hereby advised that conviction of the offense to which you could be pleading guilty or no contest may have the consequences of deportation, exclusion from admission to the United States, or denial of naturalization pursuant to the laws of the United States. Now, Ms. Patton, you have 3 plea options available to you with respect to this charge. You can either plead guilty, not guilty, or no contest. If you plead guilty, that is a complete admission by you to the complaint filed. If you plead guilty, the court will find you guilty, and then I will impose sentence. The second option is you can plead not guilty. If you plead not guilty, that is a denial by you to the offense charge, and as I said earlier, if you plead not guilty, I'll set your case for further proceedings after today, and I will set a bond. The third option is you can plead no contest. If you plead no contest, that is not an admission of your guilt, but it is an admission by you of the truth of the facts alleged in the complaint filed against you. If you enter a plea of no contest, this court will find you guilty, and I will impose sentence without any evidence being presented against you. However, the plea of no contest cannot be used against you in any later civil or criminal proceedings. Ms. Patton, do you understand all of the rights and plea options I just explained?
I do.
Do you have any questions regarding those? Okay, so with respect to this charge of disorderly conduct, a 4th-degree misdemeanor, how do you plead? Okay. Do you understand by pleading no contest that you're waiving all of your trial rights, which include your right to cross-examine witnesses and to confront evidence presented against you? You'd be waiving your right to testify or not to testify without any negative connotation. You'd be waiving your right to subpoena witnesses. You'd be waiving your right to a jury trial. You'd be waiving your right to be proven guilty beyond a reasonable doubt. All of those are trial rights you'd be waiving by pleading no contest to this charge. Is that what you wish to do?
Yes, Your Honor, but I do have a question, if I can ask.
As long as it's procedural, yeah.
With the no contest, I understand. The lady just spoke to me about everything downstairs. I just wanted to know, like, would that still show on my record, like, as guilty? Like, basically?
A no contest plea will result in the finding of guilt, and you will receive a conviction of, in this case, disorderly or aggravated disorderly conduct. So yes, it would. It just can't be used against you. The no contest plea can't be used against you if you got sued at a later time for whatever reason, or for civilly, for money, or if you have another criminal case that is related to this in some way, that your no contest plea can't be used against you. Okay, do you understand by pleading no contest, you'd be waiving all of those trial rights? Is that what you wish to do? You can change your plea. This is the time to do it, if that's what you're choosing to do.
No, I'll keep no contest. I get to speak with you, right? So like I'm saying, with the no guilty plea, they could just go from there and then.
Yeah, I mean, if you're found guilty, there is a sentencing phase, and then I would allow, as I do everyone, allow the defendant to speak before sentencing. But right now, I just want to make sure that you understand by pleading no contest that you're waiving all of those trial rights I just explained to you. Is that what you wish to do?
Yes.
Also, by pleading no contest, you'd be waiving your right to an attorney. The lady you talked to downstairs was from the public defender's office. She's here to assess and determine whether anybody qualifies for public defender before they even come into the courtroom. So I'm not sure if you would qualify or not, but by pleading no contest to this charge, you would be effectively waiving your right to an attorney, saying, I don't want an attorney to represent or advise me in this case. Is that what you wish to do?
Yes.
There's a lot of hesitation and uncertainty I'm noticing in you.
My hesitation is just coming from just the worry about like what could happen. Just that's
Okay.
as far as
Okay,
like,
so
sentence.
you understand by pleading no contest, you're waiving your right to an attorney. Is that what you wish to do today?
Yeah.
Are you under the influence of any drugs, alcohol, or prescription medications that might affect your thinking?
No, no.
Are you currently on probation, parole, community control, or post-release control with any court?
No, no,
You see, there's a warrant for your arrest out of Chagrin Valley.
no. Yeah.
Cleveland Heights, is it?
Yeah, Sugar Heights. That's for partial related to when I just seen you for my traffic case the other day. That has to do from that. They put a warrant block on my license because for my I don't know, it's like a payment hearing. I had missed that, and that's why they have the warrant for my arrest. But once I pay everything that I have to pay before I see you on the 17th, I talk to them all the time. Then that all goes away. I just have to pay $435. That takes off my warrant and the block off my license, and it finishes everything.
So
I have
let me.
to
I'm just the reason I ask. Have you resolved this warrant?
No, I am Friday.
I mean, I'm reading your criminal history background check. It says violent tendencies. Date of warrant was issued on February 5th, 2026. So you're not on probation with Cleveland Heights or any court in Cleveland?
No, I'm not on probation for it. So, Your Honor, when that happened, when I got that whole case and involvement with all that jailhouse, because that was my first time out there, I'd never been out there. The situation, I was with my friends, situation out struck with her and her ex, things got physical, he ended up slashing my
Okay, look, I appreciate you wanting to tell me what happened. My point is, the whole point of my question is, are you on probation in Cleveland?
No. I did get, after that happened, I believe it was a 6-month thing where like a probation thing, where it was like no contact, or like they didn't have to like drug test me or speak to me or nothing. I'm pretty sure, but when I just talked to Shaker Heights, I'm not on any probation. I checked.
Okay,
Because
well,
my mom asked me the same thing, and I was like, you know, when all this went down, all three, because me and my friend and her ex, we all had court the same day. And I remember that being something that was touched upon, but
Well,
I just talked to Shaker.
the reason I asked that question is if you're convicted of this charge in this court, and you're on probation or some parole or community control or anything, even pretrial diversion, which sounds like what you explained to me is pretrial diversion. If you're convicted of this, that could result in a violation being filed against you in the other court. So-
Oh, I see what you mean, a violation of probation.
Yeah.
Okay.
So, understanding that that's a possible risk, I'm not sure. Do you still wish to plead no contest to that? There's way too much hesitation here. I'm not accepting your no contest plea today. I've given you plenty of opportunity. My job, Ms. Patton, is to protect your rights and anyone sitting in your chair rights. And when I notice that someone is just too hesitant and uncertain about how to proceed, I'm going to enter no plea on your behalf to this charge. Now, you met with the public defender today. Are you asking the court to consider appointing a public defender to represent you?
Yeah, that's, when she was talking to me, she said if it's not guilty, I can have her right, basically. Is that right? Is what you're saying?
Okay. Do you have any source of income?
I actually just quit my job.
Okay. So you have no source of income?
Not at the moment, but I do have an interview at Sunoco and an interview at Cheap Tobacco out here.
Do you support anyone financially besides yourself?
No.
How old are you?
23.
Where were you working before you quit?
Lake Point, the nursing home in County Road.
Was that full-time or part-time?
That was full time.
And how much were you making there?
I was making $12.
Okay, I do find you qualified. I'm going to appoint the public defender's office to represent you in this case. Now, you're going to be meeting with that lady again. She's going to have you fill out a financial disclosure form. You're going to have to complete that today.
Okay.
Okay, the complaint has you living at 521 Madison Street?
Yes.
How long have you lived there?
About a year and a half.
Okay. Who do you live there with?
My mom, my sister, and me. We all three are on the lease.
I do believe there's some allegations of intoxication here. The law director has submitted a written bond recommendation asking that bond be set in the amount of $5,000 personal recognizance, alleging that on May 20th, 2026, the defendant engaged in persistent turbulent behavior after warning by law enforcement to desist.
Yeah.
Are you current? Listen, I'm directing the show here. This isn't a conversation, okay? Are you currently receiving the treatment services of any substance abuse or mental health agency?
No.
Bond is set in the amount of $2,500 personal recognizance. As conditions your bond, I'm ordering you not to consume or possess alcohol or drugs. You are subject to random chemical testing by probation and law enforcement. We normally have somebody from the Lake Area Recovery Center here today, but because of the long weekend, she's not here today. So I am still going to order that you undergo an alcohol drug assessment at the Lake Area Recovery Center for substance abuse issues and mental health. And if LARC, we call it LARC, recommends that you should be receiving treatment, I'm ordering that you successfully comply with any recommended course of treatment. I will set this case for a pre-trial conference in the near future when your attorney, court-appointed attorney, and the prosecutor are present to handle your case. I do have to go back. I do see in you were convicted of aggravated disorderly conduct in December of 2023 in Asheville Municipal Court, right? Are you on probation with Asheville?
No, I have nothing with Asheville. I just have tickets with them. I don't know what that is.
This says it started out as domestic violence and then ended up with a aggravated disorderly conduct conviction.
My domestic violence. I didn't know that it got dropped down to a disorderly.
Aggravated disorderly conduct, yeah. You were convicted, and so you didn't even know that you were convicted in, it appears, November of 2024. Are you on probation there, is what I'm getting at?
No, I have nothing with Asheville. I don't pay anything with them. And I don't see anybody.
Okay.
I was aware of the domestic violence. I just did not know that. Because I only ever had the one court case for it. I wasn't aware of it being dropped down before.
Well, you had to be aware, ma'am, because you had to be there. It wasn't dropped down without your presence.
Mm-hmm.
Okay, so here's what's happening. You're being released today on your own recognizance. I've added conditions to your bond. You're to stay drug and alcohol free. And you're ordered to undergo this assessment at the Lake Area Recovery Center. The clerk at the window will give you all the information you need that you need in order to contact LARC and to start that assessment process. And you're also ordered to successfully comply with any and all course of treatment. So if you fail, we're going to give you a hearing date for your next hearing. If you fail to come to court on that date, or if you fail to comply with those conditions of your bond that I've just set, I will issue a warrant for your arrest. And if you are arrested, I'll make sure you sit in jail for as long as I can keep you there. And then also, I could order you to pay the City of Conneaut $2,500 as a penalty. Do you understand all of that?
Yes, sir.
Do you have any questions?
Yes, so from now at this point, you said no plea. Is that moving on? Are we basically moving as a no guilty
Yeah,
trial?
it's much like a not guilty plea, but I'm entering no plea on your behalf, and we can enter a plea later with your attorney's involvement.
Okay, and then you said large. Are there specific days that you want me to go and have this done?
You'll have to. It's all based on their availability and
Okay.
schedule. So we're going to give you the contact information. It's going to be up to you to contact them immediately to schedule that assessment.
Okay.
Okay? Anything else?
No.
Okay, you can go to the clerk's room. They'll take care of you. Thank you.
Have a good day.
You too.
Okie dokie, friends. Let's go up to Michigan. Judge Tony Flores. Say good morning there.
James Harris here on behalf of Mr. Jordan Gwynn, who joins via Zoom. He does apologize for being here via Zoom, Your Honor. He emailed me this morning indicating that he had, I received an email from him this morning indicating that he had a new job that had essentially asked him to come in today rather last minute, and he didn't have time to check the court about it. He indicated that he's been trying to find a new job for a while and did not want to do anything that could cause him to lose this job. He asked if Zoom would be appropriate here, and given that the parties did not expect the jury trial to run and didn't expect to handle an offer today, I advised him joining via Zoom would potentially be better than not joining it.
All right. Okay. And sir, you are Jordan Gwynn, is that correct?
Yes, sir.
All right, thank you. This time set for a jury trial today. It was on a no ops, and it was previously indicated that this was not going to go. Mr. Boot, how are we proceeding today?
Yes, Your Honor. This comes before the court on a ticket. The agreement would be to plead to charge 2 of the no ops as charged with a Killebrew to no upfront jail. That would be, it's my understanding that you would be in acceptance of that. I believe count 1 was a civil infraction that has been resolved or has since defaulted.
All right, and what is the fine on the?
The failure to display, Your Honor, is up to 90 days and or 200.
That is correct.
2. Or 200. That's count 2 of the ticket, drive while licensed, not valid or proper, and there's a Killebrew agreement of no jail time. Is that a fair statement, Mr. Harris?
Yes, Your Honor, that is a fair statement of the offer, and at this time I have spoken with Mr. Gwynn, and Mr. Gwynn indicated he would like to accept the offer. After the court puts the factual basis on the record, I would request that the court move to immediate sentencing.
All right, thank you. Is there any objection to the court moving to immediate sentencing at Mr. Booth?
No, Your Honor.
All right. Mr. Gwynn, you have some rights in this misdemeanor case. I'm going to walk you through those rights. You have the potential of looking at 90 days in jail and or $200. There's a Killebrew agreement between Mr. Harris and the city of Lansing that you receive no upfront jail as a part of this sentence. If I was going to do something differently, you'd have the opportunity to withdraw your plea. Do you understand that, sir?
Yes, sir.
All right. You have some rights in this misdemeanor case. I'm going to walk you through those rights. You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question any witnesses that are brought against you. You are represented today by Attorney James Harris, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan, people of the city of Lansing. Do you understand that, sir?
Yes, sir.
You have the right to have the court order any witnesses appear in your defense, remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim the plea was a result of any promises other than what we've stated on the record, or threats it was not your choice to plead guilty. You'll also be giving up the right to appeal anything from trial. Since you won't be having a trial today, you'll be pleading guilty to the misdemeanor instead. Is it still your wish today to plead guilty to the misdemeanor instead?
Yes, sir.
I'm going to have you raise your right hand. Do you solemnly swear or affirm, tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
I'm going to bring your attention back to That would be December 13th, 2022, at the offense location of West Saginaw in North Sycamore in the city of Lansing. Were you operating a motor vehicle on West Saginaw, North Sycamore in the city of Lansing on December 13th, 2022?
Yes, sir.
And at that time, did you not have a valid driver's license on your person?
Yes, sir. I did
As a
not.
matter of fact, you didn't have a valid license at all. Is that correct?
Yes, sir.
All right. Anything towards a factual basis, Mr. Boone?
Nothing from the city, Your Honor.
Mr. Harris?
Nothing from the defense, Your Honor.
I find the factual basis to be knowing, voluntarily, and accurately made. And I will follow the Killebrew agreement of no jail. And then immediate sentencing allocution of Mr. Harris.
Yes, Your Honor. Unfortunately, Your Honor, Mr. Gwynn was trying to achieve compliance in this case to hopefully, well, achieve a bit of a better resolution. However, he was advised that, well, there was at least this case he would need to get resolved before Secretary of State would be willing to essentially work with him on trying to get his license back, and that he would be unable to achieve compliance at this time. The parties essentially worked out this offer. Given that information, it is unfortunate Mr. Gwynn was unable to achieve compliance at this time. I would simply request that the court would consider fines and costs, minimal fines and costs at this time, so this case can be resolved and Mr. Gwynn can take what steps he needs to try and achieve compliance or get his license further down the road.
All right. Thank you. Anything from the city on concerning allocution, Mr. Abood?
No, I would defer to the court, Your Honor.
All right. I will stick with the Killebrew agreement there. So there's Killebrew, no jail. There'll be no probation. We'll set fine at $75, cost at $75. Crime victims' rights fee of $75, and then I'll waive the state fee. So that'll be $225 to the city of Lansing. And does your client need some time to make that payment to the city of Lansing, Mr. Harris?
Mr. Gwynn,
Yes.
do you think
Yes.
you can get that paid in 60 to 90 days?
Yes, sir.
All right.
Yes, sir.
I would request,
Just
I
need
would
to
request
get-
the 90
just-
days, just to be safe, Your Honor.
Yeah. So let's do 90 days out. What are we looking at 90 days?
August 24th.
Perfect. All right, so we'll have $225 to the city of Lansing on August. So it can be paid by August 24th. You can make up your own payment plan as long as it's all paid by August 24th. That can be paid online, in person, or at the counter. And you should keep in contact with the City of Lansing Criminal Department just to let them know the status of the payment, so you stay out of the show cost cycle. All right, Mr. Gwynn?
Yes, sir.
All right. So I've got, so we said $225 by August 24th. Anything else for the record in 22-03509, Mr. Boone?
Nothing from the city.
Mr. Harris?
Nothing from the defense, Your Honor.
All right, you're all set, Mr. Gwynn. Thank you for your appearance today.
All right. Thank you, Your Honor. You guys have a good day.
You too. All right.
Okay, friends, good morning once again. TCF Live on a Tuesday. So as often happens when we take a few days off here, you get back into the studio and you find glitches that have never existed before. Why does that happen? Don't know, but it does every single time. So here's what's going on at the moment. You guys don't see it, but I'm having all sorts of issues with OBS right now and it freezing up. So I'm going to take about a 60-second timeout and restart this thing before it becomes a real problem. So don't go anywhere. Stream is not dying, but the feed's going to go dark for a minute while I restart things. So just hang tight, bear with Okie dokie, friends, we are back. Apologies for that little pause there, but let's get back to Judge McNally.
Judge Sean Smith on behalf of Mr. Morris.
Judge, there's a victim on Zoom also.
You're Ashley Norris?
Yes.
Ms. Holloway, is she on this? Is Ms. Holloway on this?
Yes. Oh, I do, grab it.
Yeah, would you?
Yeah, thank you.
I'll be right with you, Ms. Norris.
Thank you.
Good morning to you. How are you, Ms. Holloway? Your name? All right, Ms. Norris, your name again?
Ashley Norris.
Mr. Smith?
Sean Smith, P number 51431.
Mr. Norris?
Brett.
Listen, I know you guys don't like to, I can't just dismiss this face. So you're gonna move to Nolly Pros, correct? You're gonna fill that out Sadie, can you hand her that? Ms. Norris,
Yes.
you don't want to proceed here?
I am okay with dismissal.
That means you don't want to proceed?
No, Your Honor.
Who called the police?
I went to the station.
Okay, so I'm not gonna ask you any more questions. You initiated a complaint.
Yes.
To me, once somebody makes a police report, especially when they initiate the charge, they should go forth with it. I'm not gonna make anybody do anything unless they subpoena you when you don't show up. But just recognize that a lot of people did a lot of work on this. Are you with me?
Yes.
So people move to Nolly Pros. I'm gonna go ahead and dismiss the case. And Lisa, we're gonna make sure we take all the bond conditions out, okay? Included no contact, no firearms, no weapons, not to enter the property address. So we'll take that out and all those bond conditions are lifted. Thank you, Ms. Holloway.
Thank you.
Case dismissed. Good luck. Thank you both.
Thank you.
Best of
Thank
luck
you,
to
Your
you.
Honor.
Thank you.
Just have a question.
Sure.
So I understand that you want people to move to Valley Plus. Would you?
If your witness doesn't show up for trial, that's different.
No,
But-
I understand. I mean, so like right now, would you be okay if I said no objection to the defense's motion to dismiss?
Not on something like this. I don't, do you understand? You're just telling me she's uncooperative. That's fine. It's your case. It's not mine. And I know they don't like to have anything where they're moving to dismiss anything anywhere. But I'm not going to dismiss it because your victim's being uncooperative and doesn't want to proceed. That's up to you guys to Nolly Pros. Please don't send them in. I mean, I don't know why it's gone this far. You know, like the last guy, Judge Hessen's case, where you're saying no objection to closed case, or I don't know if you did it or Ms. Ismaro, that's not appropriate. I mean,
I was just wondering what the court was.
no, I know. I'm not getting on you. I think guys take directions from people that,
You know, with all comfort, the court, this prosecutor is very diligent.
she's a good prosecutor. I'm not complaining about her.
I think justice is.
I'm not complaining about her. She does a good job. But sometimes they take directions from people and maybe I don't agree with those directions, but that's neither here nor there. Thank you very much. Have a good day.
See you. Thank you.
Jaden Lamont Weber, 26W842606A.
Good morning, Your Honor. Attorney Corey Westmore, appearing on behalf of Mr. Weber. Weber, would you please state your full name for the record?
Jaden Lamont Weber.
What happened?
Aye.
He didn't show up on the 20th.
I was at work. I just started my new job.
Well, did you bother calling anybody at the court and saying, hey, I can't make it today? Can you please reschedule or did you just skip?
Honestly, it flew right past my head. I gave an estimate to myself in my head when they coordinated. So I still wasn't constant checking. So that.
Just don't let it happen again, okay?
It's okay.
So we're rescheduling this, Lisa. It's a Woodhaven case. It's in front of Judge Hessen, so this is gonna go on what day? Oh, you might have written it on here. I'm sorry if somebody did. We're gonna reschedule to June 17th at 10. I'm sorry. Reschedule to June 17th at 10. I'll just make a note. Defendant appeared today. Okay, so you go down the hall and we cancel the warrant. I'll reinstate the bond. I don't even know if she gave you a bond. Actually, it doesn't look like he was arraigned. Does he stand mute? Waive formal reading?
That's correct.
Not guilty plea is entered. I'll indicate that he stands mute. And I will go ahead and give you a $100 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed, okay? So you go down the hall, get your notice. And if you want a court-appointed lawyer going forward, you're gonna have to fill out a petition for one, okay? Where do you work at?
Work at agent and package.
How much do you make?
He just started 3 weeks ago.
Kids?
No.
Married?
Full-time student at Wayne State.
Okay, you fill out your petition. You'll
Oh,
probably,
he did fill
okay,
it.
okay, good enough. Thank you very much. Go down and get your notice. Good luck, sir. Wayne State, what are you studying?
Civil engineer.
Good. Good. Don't miss court dates though. All right.
Alrighty, friends. Well, he searches for another contestant. Let's go down to Jackson County, Florida, but we have Judge Colby Peel handling first appearances this morning. So let's check that out.
Judge Peel in Washington County, covering for Judge Mercer this morning. I have with me on screen Ms. Ford from the State Attorney's Office, Ms. Parrish from the Public Defender's Office, and I think I have another gentleman on. Tell me, sir, are you?
Yes, you're Tor Friedman for Joyce Burns Medley.
Okay, thank you, Mr. Friedman. Mr. Friedman
Yes, sir.
is on to represent Ms. Medley here in a few moments. Before we get started, Ms. Parrish, I'll appoint you to represent the other individuals there for first appearance purposes this morning. If you'd like to give them some advice before I get started, you're welcome to do so at this time.
Thank you, Your Honor. Mr. Williams, Mr. Polk, Ms. Hazelwood, this is Laura Parrish. I'm Assistant Public Defender. At this time, this morning's hearing are for bond or release purposes only. The judge will decide if probable cause exists. If he does, he will be setting a bond or a release option. This is not the time to talk about the facts of your case. Please do not talk about the facts of your case. If the judge asks you any questions about where you live, where you work, your ability to stay away from anyone, feel free to answer those. Just don't get into the facts of the case.
Thank you, Ms. Parrish. We'll start with James Williams. Mr. Williams, if I could get you to step forward, please, sir. Mr. Williams, you had an opportunity to watch the video regarding first appearance rights. You heard the advice that Ms. Parrish just gave. Do you have any questions about your rights this morning?
No, sir.
All right, sir, you're here on a violation of state probation. It's case 25-133 out of Jackson County. You were on state probation for possession of a controlled substance. They've alleged that you violated your probation by failing to enter the Chrome program and remain in compliance with the rules and regulation, in that they received a Chrome departure letter dated 5/17. So based on that, Judge Garcia has signed a warrant. She has ordered that you be held without bond. So I'll hold you without bond this morning per her warrant. They'll get you back in front of her on her next available arraignment date. If you can hire an attorney, do so. If you can't afford to hire an attorney, the Public Defender's Office will be appointed to represent you when you come back to court. Do you have any questions this morning?
No, sir.
All right, good luck to you, sir.
Yes, sir.
Next case I have is State of Florida versus Dennis Polk. Mr. Polk, if I could get you to step forward. Polk, good morning. You had an opportunity to watch the video regarding first appearance rights. You heard the advice Ms. Parrish just gave. Do you have any questions about your rights this morning?
No, sir.
Mr. Polk, you're here this morning charged with battery, a misdemeanor. I've reviewed the affidavit complaint, found there's probable cause for the charge. I've also had an opportunity to review your prior criminal history. Mr. Paul, you live there in Jackson County. How long have you lived in Jackson County?
About 6, 7 years.
Okay, do you work anywhere currently?
Yes, I work for Anderson Columbia
Okay, how long have you worked with them?
over 5 years.
Mr. Paul, I'll set you a bond this morning based on the information I have. I'll set you, yes, sir.
There was no hands put on each other.
Oh, okay, all right.
Well,
Well,
nobody put no hands on each other.
all right, and I understand they've arrested both of you, so I'm going to talk to both of you this morning. I'm going to set you a bond this morning. I'm going to set your bond at $1,500. Let me ask, do you wish to have contact with Miss Hazelwood or no?
Yes, yes.
Okay, all right. Currently, your bond is set at $1,500 with a condition that you have no contact with Miss Hazelwood. Miss Hazelwood, if you're there, let me get you to step over. And Mr. Paul, let me get you to step out of the way, and I may come back to you in just a moment, okay? Miss Hazelwood, good morning. You had an opportunity to watch the video regarding first appearance rights. You heard the advice that Ms. Parrish gave. Do you have any questions about your rights this morning?
No.
All right, ma'am, you're also here charged with a misdemeanor battery. I've reviewed the affidavit complaint, found there's probable cause for the charge. You live in Jackson County as well. How long have you lived in Jackson County?
5 years.
Okay, and I've had an opportunity to review your prior criminal history as well. Do you work anywhere currently?
No.
Okay, do you wish to have contact with Mr. Paul?
Yes.
Okay, are the two of you married or just live together?
Live together.
Okay. All right, what I'm going to do this morning is I'm going to, based on what I have heard, I'm going to, well, let me ask you, has anybody forced, threatened, coerced, pressured you to get you to come in and say you want to have contact with Mr. Falk or anything like that?
No, sir.
You may not have even known I was going to ask that. What I'm going to do is give you an option this morning. I will give you a conditional release, which gets you out of jail without you having to post bond. If you take that, you'll have to report to a conditional release officer on a weekly basis. There's a monthly fee for conditional release. Or I'll set you a $1,500 bond, and I'm going to order you to have no violent contact with Mr. Dennis Paulk. So I'm going to allow you all to continue to have contact as long as it's not violent. I'll give you an option. If you want to take the conditional release, you can. If you want to post the $1,500, you can. That'll be your choice. Ma'am?
Yeah. I'm the least, get the other one, not 1,500. Huh? The lease.
Okay, all right. I'll give you that choice, okay? So you can do whichever one you choose. Just make sure you have no violent contact with Dennis Paulk, okay?
Okay.
All right, and good luck to you, man. Mr. Paulk, let me get you to come back over now. Mr. Paulk, I had set you a $1,500 bond. I'm going to also give you an option. If you want to take a conditional release, I will give you a conditional release with the condition you have no violent contact with Carolyn Hazelwood, okay?
Yes, sir.
You have any questions about that?
No, sir.
All right. So in both cases, officer, it's a conditional release or a $1,500 bond, no violent contact with each other. For the record, in the affidavit complaint, it alleges a push in the back and it alleges a grabbing of the wrist by the other one. So those are the allegations. So I think it's appropriate based on the nature of the charges and their request this morning to set bond, as I have just said it. Good luck to both of you.
Yes, sir.
And the last case I have is State of Florida versus Joyce Medley. Mr. Friedman is present to represent Miss Medley. I have a warrant signed by Judge Mercer. Let me ask Miss Medley, is Miss Medley present?
Yes, she's coming.
Okay. Ms. Medley, good morning. Did you have an opportunity to watch the video regarding first appearance rights?
No, sir.
Okay, let me make sure you understand everything we're doing this morning is being recorded. Also, you have the right to be represented by an attorney. Mr. Friedman is present on your behalf. And I'm not even going to talk about the last part based on what it says on the warrant this morning. So, and that's the bond issue. You've been charged with burglary with a battery, which is a first-degree felony punishable by up to life in prison, which is extremely serious, obviously. You've also been charged with false imprisonment, a third-degree felony punishable by up to 5 years in prison and up to a $5,000 fine. Ms. Ford, Mr. Friedman, the warrant that Judge Mercer signed says she will be admitted to bail in the amount of, it says notice to appear upon notice from the clerk. Law enforcement chose not to arrest at the time of incident. So I think that it is Judge Mercer's intent, based on what I'm reading, despite the serious nature of the charges, for me to give her a notice to appear this morning. Ms. Ford, I reviewed the affidavit complaint. The allegations are that there's a probate case ongoing, I guess. She is alleged to have reached into a vehicle and grabbed someone by the hair. That's the allegation. And also there was an allegation that her vehicle was parked behind another vehicle. They were meeting at a house to exchange a walker, is what it sounded like. Ms. Medley has no prior criminal history. Mr. Friedman, I'm not trying to not allow you to talk. If there's something else that you want to tell me, you let me know. But it looks like the court is authorized the notice to appear in this case. If there's anything you want to add, Mr. Friedman, this morning, you certainly can.
Yes, Your Honor. I spoke with ASA Jake Mitchell. This was originally a misdemeanor, and then it got upfiled to the charge at hand. My client was notified of this yesterday and turned herself in after going to church. We have no objection, of course, to a notice to appear.
All right. Mr. Mitchell, are you on with me now?
Yes, Your Honor. This will
You have-
likely be my case, so that's why I was joining in. Judge Mercer spoke to me about that issue, about what happened, and I'm aware of the notice to appear when it comes to Ms. Medley. And I've spoken with Mr. Friedman, and we're both in agreement to that. I think the only thing we can do, if the docket's not set yet, is set her for the June 2nd court date in the afternoon.
Okay. All right. Then what I'm going to do this morning is give her a June 2nd court date. What time would that be at? 1 o'clock or 1:30? Do you know, Mr. Mitchell?
It's 1:30.
1:30. All right. 1:30 on June 2nd. Officer, if you will give her a notice to appear for that date. I am going to order that she have no contact with LaWanda Bamberg until further order of the court. She's the alleged victim in this case, and just in an effort to protect all parties, but the alleged victim, I'm going to order no contact. For the record, I did review Ms. Medley's prior criminal history. She has no prior criminal history. And so based on what Judge Mercer has entered on the warrant, I'm going to order that she be released at this time with a notice to appear. Ms. Medley, do you have any questions?
Yes, sir, I do. I have one. My husband is a heart patient. He's a stage 4 kidney patient. He has bladder cancer. We don't know if he has been approved. We've been with advanced urology in Tallahassee for a couple of years, several years. I can't tell you exactly, but we've been to Gainesville on several occasions, several times. They are to notify us in about 3 weeks of his approval, and he is to be given, it's called the pretzel. It's a new cancer procedure.
Let's don't get in too much into his health issues, just because this is probably being broadcast all over the internet. Is your question if you can travel? I'm not placing any restrictions on your travel. And as far as court is concerned, you just make sure you stay in contact with Mr. Friedman as to what you've got going on. Okay.
My question was if it were happened to be that date.
So you let Mr. Friedman know, and he'll take care of that with the court. Okay. I understand.
Okay,
And that's a legitimate question. I wasn't trying to cut you off. I just didn't want you putting too much private information out there regarding your husband. Okay.
I apologize.
Officer, she can be released, and just stay in contact with Mr. Friedman. Okay.
Yes, sir.
All right.
That's all I have, Your Honor.
Take care of
Maybe
everyone for first appearance in Jackson County.
That's everyone.
Thank you. You all have a nice day. Miss.
Well, ma'am, I know of at least 60 people now who know probably more about your husband than you wanted them to. Good morning once again, everybody. TCF Live, about to enter hour 2. Barbara, thank you for the $5. I missed you as well. You know, long weekends are nice. Quite honestly, I probably needed the break, but I missed being here with all of you. So it's good to be back. Yeah, this is the best thing I've ever done. So thank you all so much. And judging by the stats, there's probably a lot of new people out there this morning. If you are new to the channel, take a moment and say good morning to us in the chat. We're a friendly folk. You've stumbled into one of the best places on YouTube, in my humble opinion. Let's go back up to Michigan. We will say good morning to Judge Simpson.
Raymond Cook for the people.
What's your name, sir?
Thomas Basher.
Sure. Boy, yeah, this is a public defender. May I have a brief moment, Your Honor? Let me.
I think we're trying to enter a plea.
Okay. Where's your attorney?
Case. Young Jim.
Oh, want him?
No.
No, okay. Very brief indulgence, Your Honor. Let me.
Dinner with.
Oh, okay. Here, may I just step in the hall very briefly, Your Honor?
Sure.
Thank you.
Yeah.
The light.
That light is something you're right. There is my hands.
Joy Gaheen, Senior Assistant Public Defender. Good morning.
Morning.
Good morning, Your Honor. Assistant Public Defender Ben Denowitz for Mr. Vasher, who is standing to my right.
Your name, sir? Thomas Basher. Have you actually formed an independent contest to an added count, larceny less than $200. That I finally successfully completed that charge. Counts 1 and 2 would dismiss. Defendants agreed full restitution on all counts. That supports full understanding of the agreement.
Yes, that is. It's in the.
Is that correct?
That's
What is? Yeah, yes.
Okay. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do. Thomas Basher. Basher, it's just court to understand you're going to plead no contest to the charge of larceny less than $200. That's punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased. Attempts to value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that? Yes, Your Honor. All right. Do you understand what a no contest plea is? Yes, Your Honor. Things about it, I have to make sure that you understand. The first thing is, you know what you're going to have to do. And first thing about a no contest plea is it means that you're not further desirous or wanting to contest this charge. You're going to have to do something about that. You're going to have to put something over it because it's coming right in at me. I don't care.
Doors or the windows. It's the windows.
I don't care that it can't come in. The second thing you need to understand is that for purposes of sentencing, the court's going to treat you the same as though you had pled guilty. You understand that? Yes. All right. You understand, sir, also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Garwood in the 15th District Court. Yes. All right. Still wish to plead no contest? Yes, sir. Basis for the no contest plea?
Civil liability.
And sir, to that charge, how do you plead? No contest. Now you understand that by pleading no contest, you'll not have a trial of any kind. Yes, sir. Signed an advice of rights form, is that correct? Yes, sir. Question regarding any of those rights? Oh, yeah. Look at paragraph 5. You'll see a copy. Those are your rights which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights on that form. Yes, sir. You understand you're giving up your right to appeal of right. Yes, sir. Are you on probation or parole? Has anybody promised you anything other than what's been stated here today to get you to plead? No, sir. Anybody threaten you or coerce you? No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
Court has been provided and has reviewed Ann Arbor Police Department report for their case number 25-24098. Any objection to the court having reviewed that report?
None from defense.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined in Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, Your Honor.
Your Honor,
Counsel, you're aware of any other promises, threats, or other inducements which have led to this plea?
none from defense.
And have I complied with the court rule?
People are satisfied.
Yes, Your Honor.
Court will accept the defendant's plea to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation.
Your Honor, would the court consider immediate sentencing? He has 89 days, he has actually 125 days credit. He went to treatment, he came back and has 89 on the current.
Restitution?
Restitution would be 500.
Yes, we're agreeable on 500 restitution.
You should have let me know that you wanted that beforehand. I'm not going to immediately sentence him. Is this the only thing he's held on?
No, he's got a DV case, but the bond is only 10,000, 10%, I believe. And he tells me his sister was going to pay that if he was going to get out on this case. So
I'll give him a PR. I don't have, if that's the number of days, I don't have a problem with that, but I'm not going to sentence him.
okay, thank you, Judge.
June 23rd, 2026. 9/8 before Judge Garwood. Bond in this case is to a $5,000 personal recognizance bond. Thank you.
You're going to get out, you're going to have to show up.
Just be in custody.
Robin Rogers.
Court calls case People versus Terry Williams.
Morning, Your Honor. Raymond Cook for the people.
Good morning, Your Honor. On behalf of the Attorney Nicholas North, Your Honor, unfortunately, I have not been able to make contact with Mr. Williams. I haven't seen him here today, not in the hallway, not in the courtroom. For him not being here, I've been texting and calling.
And Your Honor, for the court's consideration, the people are not here. Frankly, I don't think I will be able to proceed at a future date. We've not had contact with the victim.
Well, he needs to get here, otherwise he's gonna get a warrant for a dismissal.
Your Honor, I can keep calling.
Keep going.
Thank you.
Court calls case People versus Anthony Reeves.
Morning, Your Honor. Raymond Cook for the people.
Good morning, Robert G. Cook on behalf of Mr. Reeves, who's in lockup, approaching the podium. Anthony, when you get to the podium, would you state your name for the record?
Anthony Lamar Reeves.
Thank you.
Time of day for a preliminary exam, the submitted defense is ready to proceed.
People are not able to proceed with this.
I ask the submitted to be dismissed.
For being unable to proceed. This case is dismissed. That's on the defendant of the defendant's motion without prejudice. Thank you.
Thank you, Your Honor.
Court calls case People versus Enrique Davis.
Your Honor, President of the people. James, Senior Assistant Public Defender, representing Mr. Davis from Burbank.
Eric Davis, I'm sorry. I always get one name.
Eric Davis.
Thank you.
Your Honor, unfortunately, one of my witnesses is not able to be here today, so I'm not able to proceed.
We'd move for a dismissal.
People being unable to proceed, this case is dismissed. That is without prejudice on the defendant's motion. All right. Thanks.
Thank you, Your Honor.
Thanks. Good, I don't have to call your name anymore.
Alrighty, friends, let's move along. By the way, T, thank you for renewing your membership. I appreciate that. Let's go to Judge O'Donnell down in Lake County, see what's going on there this morning.
CR 402, State of Ohio versus Douglas Powell. The defendant is present, represented by counsel John Fatika. We were last here on April 24th when the defendant waived guilty to a one-count information, that being possession of cocaine, a felony 5 with a forfeiture specification. A drug and alcohol evaluation and pre-sentence report have been completed. The parties have had the opportunity to review those and are prepared to proceed with sentencing today.
Fatika.
Good morning, Your Honor. I've had an opportunity to review the PSR and the drug and alcohol evaluation. We're ready to go forward.
Okay, go ahead.
Your Honor, I'd like to highlight the fact that while Mr. Powell only has 7 days of jail credit, he's been in the Lake County Jail since March 20th of this year for a total of 67 days. During that time, he's had no institutional violations. When approached by law enforcement in this case, he admitted that he had no operator's license and that there was a warrant. He has no warrants now. We'd ask to...
What was the sentence for in Painesville?
I believe it was a probation violation, but I'm not positive.
Okay.
Your Honor, it was a probation violation on a 2025 drug abuse instrument case.
Okay.
Yeah, that's what the PSR shows as well. As you can see from the PSR, Mr. Powell's mother passed away when he was 17, leaving him with an inheritance. I think that began the downward spiral. More recently, his girlfriend passed away. I think that threw him into another tailspin. We'd ask the court to consider the recommendations contained in the drug and alcohol evaluation, which include residential treatment and a period of sober living. Thank you.
What do you want to say?
Your Honor, I've struggled with drug addiction my whole life since I was probably about 13. Started with my mother and my father, split ways, carried on all the way up until now. I've had residential treatment one other time in 1995. My mother passed away shortly after. I'm not making no excuses for anything I've dealt with. I hold myself accountable for all this. I need help.
Tell me what that means. You hold yourself accountable for all this.
I'm not blaming nobody for any of my actions or any situations. I always have a choice. I can either say yes or I say no. I have trouble saying no, and I need help with that. I need support. Since I've been in jail, I reconnected with a guy up at AA. He was part of my home group in 2014. Men of Plains, Men in Action. I've attended AA every time it was offered to me while I was in the jail. I think residential treatment is a good spot for me. I can focus on my addiction.
And then what?
I could be there for my family, for my kids. I have 4 children that miss me. I miss them. I could be reliable to my employer.
Who's your employer?
Nobody right now.
Who's your last employer?
My last employer, I was self-employed.
Doing what?
Power washing and lawn maintenance, junk removal, and metal recycling.
Metal recycling?
Yes, sir.
Well, why were you doing that instead of working for somebody else on a regular basis?
Because I was addicted to drugs and unreliable for anybody else.
So how are you suddenly, after 30 years suddenly going to get reliable?
Hopefully through the help of Alcoholics Anonymous.
Okay, well, you've been there before, right?
I have.
Okay, so why didn't it work?
So I didn't apply myself fully.
Why not?
I didn't know how to. Kept going back to the drink, going back to the drug.
Isn't the purpose of that program to teach you how to?
It is. I didn't follow the steps completely.
Why not?
Tried using my own will instead of the will of my higher power, Your Honor.
How many times you been through this ringer?
As far as
Sitting there before somebody like me telling that person whatever you want to tell them to try to get the best way out of this as possible.
This is actually the first time I've asked for treatment, Your Honor.
So this is the 22nd time on criminal cases, either misdemeanor or felonies, you've been before a court. And this is the first time you ever asked for treatment?
It is.
Why?
All the other times I've ever went in, I just wanted to get out of jail as fast as possible. And whatever was offered to me, I was taking it. And I'm tired of not
What do you
being...
mean what was offered? What was offered to you?
A more lenient sentence, getting out of jail right away, or
going to NeoCap, right? Or going to Glen Bay.
Yep. NeoCap, I went willingly.
Or going to Sherrick.
Sherrick, I did that off the streets.
Or going to Ravenwood.
I did that off the streets.
You told me you didn't do
myself.
any treatment before.
I said I've never asked for it.
Jail treatment program, Geauga. You never asked for it, then why'd you
No.
do it?
For a lighter sentence. Right now, my worst case scenario would be being released, being back in the streets and being left to my own demise with nothing.
Well, that may be your second worst case scenario, right?
I believe it'd be my first worst case scenario. Your Honor.
What's your second worst case scenario?
My second worst case scenario would be prison.
Well, you're left to your own devices to get drugs whenever you want in that case too, right?
I would be.
Is that what you did when you went the last time?
No.
Why not?
Because as soon as I went in, I went straight to educational and got my certificate in horticulture and started with business management out of Ashland University and educated myself.
And then what'd you do after that?
I came out and worked for my father-in-law,
Where?
Integrity Dental,
Doing what?
dental service and repair technician,
And how long did you work there?
approximately 2 years,
Till when?
2023.
Then what'd you do?
Left for Power Washing Company, Sparkle Wash out of Bedford.
Why'd you do that?
More money.
Okay, so what happened after that?
My girlfriend got sick with cancer. I became her primary caregiver and she passed away.
And when was that?
2024, June.
So then what? What happened after that?
I just kind of floated around.
Where was your sponsor during all this?
I didn't stay in contact with my sponsors.
Why not?
Thought I had it.
What do you mean you thought you had it?
Thought I didn't need them.
Okay.
Thought I could do it on my own.
So this is in 2024?
No. I haven't been involved with Alcoholics Anonymous since 2014.
Okay. So you thought you didn't need them. So when you were, were you making meth in there in Geauga County back in 2015?
Yeah.
You didn't need them then because you thought you had what? A handle on your drug problem?
I thought.
And you're making meth?
Thought I'd make it for myself instead of spending money for somebody else.
And you thought you had it in 17 in Union County when you were making more meth, right?
On the run, Your Honor, yes.
Why in the world would you think you had it if you're making meth to feed your habit? What you had what? You thought you had what?
I don't know what I thought I had. Thought I had a way out of not being caught, living in the woods, living as a vagrant, being away from my family.
What family?
My children, my wife.
Okay. And who are they?
Sky Malidi, Trinity Malidi, Douglas Powell, Dante Malidi, and Nicole Malidi.
And where are they?
My children are with their grandparents. One of them's growing up, is still living there, going to college right now. And my wife, me and her have been separated since 2014.
Where is she?
I don't know where she's at. I don't stay in contact with her.
So which one's in college?
Sky, my oldest.
Where's Doug?
Doug's in high school, graduating this year.
Where?
Out of West Geauga, Chesterland.
Where's Trinity?
She's also in high school.
What year?
She is a freshman.
What about Dante?
Dante is in boarding school.
Boarding school, where?
I don't know where the school is.
Okay. How long has he been in boarding school?
He's been there for a year, Your Honor.
Why don't you know where he is?
I don't speak with his grandparents very often.
How often do you speak with your kids?
My two older ones I spoke with almost every day.
What do you mean spoke?
Spoke with them, talked to them on the phone.
When?
Almost daily.
When's the last time?
My oldest daughter, I haven't spoke to her since the beginning of March, right before I went into jail.
What about the other ones?
Trinity, I haven't spoke to since, had been before Christmas. And Dante, about the same. Douglas, I haven't spoke to him since the beginning of March as well.
Maybe you shouldn't be back around them. What did you contribute to them growing up?
I try to contribute being a role model. I'm not allowed around them when I'm high. I'm not allowed around them when I'm drinking. I try to speak words of wisdom to them and explain to them what not to do in life.
Why don't you take your own advice?
I need to.
I know you need to. Why don't you?
That's what I'm trying to do right now.
There's one thing that you do know for certain, right? What's that?
I'm a drug addict, alcoholic.
What else do you know for certain?
That I need to change.
Right? What else do you know for certain?
that I love my family. I can't do it if I'm locked up.
Right. Well, but you need to be locked up. Didn't you just say the worst thing that could happen is for you to get out? Don't you need to be locked up?
I need help is what I need.
Right. What you don't need is neocap though, right?
I don't think so, no.
You don't think so? And you don't think so, why?
Because it's not solely focused on addiction. It's focused on, I think, up to 13 different things: budgeting, aggression, anger, parenting. There's a lot of stuff that goes on with neocap aside from addiction.
See, the problem is that you profess to know what is best for you, and you're 49 years old and have been in and out of jail since you were 18. But you profess to know what's best for you, right? You profess to be a role model for your 4 kids when you've been in and out of jail since you were 18. And you profess to be a role model for them by telling them what not to do. And then you turn around and do the very thing you're telling them not to do. Is that right or is that wrong?
You're correct.
Okay. Now, where were you going the day you got arrested?
Where was I going?
Yeah.
I was coming back from picking up money from a job I'd done.
And why were you driving?
That was the only way I had to get to where I needed to go.
Why don't you get a license?
I was working on it, and
what do you mean you were working on it?
I was working on paying off all my fines through the municipal court. And I went to Citizen Circle, and while I was at Citizen Circle, they offered a program to where once I got my fines down to a certain amount, that they pretty much picked up the rest. And while I was doing that, they ran out of funding, and at the same time, I had an agreement with a guy to buy a truck, and it all fell through. And
When did the agreement for the sale of the truck fall through?
While I was paying off all my fines.
When was this?
Pardon?
When?
Last year. Last summer.
So last year, in the middle of your throes of your drug addiction, you expect me to believe that you're going to sell this truck, get your hands on some money, and go pay fines so you can get your license. Instead of buying meth, right?
I was paying on my fines. I was working, Your Honor. I was doing stone masonry.
Well, not in 24.
Not in 24. I was dealing with a sick woman in 24.
Right. You have an answer for everything.
I try to.
Well, you do. Whether it's complete bullshit or not that doesn't seem to matter to you, okay? Because I cannot, for the life of me, believe that a severe drug addict of 31 years is going to sell a truck and then go to Podunk Municipal Court and pay fines.
I never
instead of
said
buying meth.
I never said anything about selling a truck. So I was trying to purchase a truck. I was working for a living to purchase a truck, to go to work, pay my fines, to follow through with probation.
How are you going to purchase a truck if you don't have a license?
People do it all the time.
They do?
Yeah. People do purchase vehicles
how do you legally do that?
I don't know. People do it all the time. People have chauffeurs who they purchase their vehicles and they drive.
How do you know this?
I don't know, I mean, it's an assumption, but there are people out there who don't have license who purchase vehicles.
Can you name me any of those people?
No, not off the top of my head, Your Honor.
So you don't really know that.
No, it's an assumption, as I stated.
Trying to, it's hard to work with somebody like you off of assumptions.
Your Honor, I'm not bullshitting you on anything here. I have an addiction.
I know you have an addiction.
I'm not trying to get out of anything.
The problem is
I'm
not
trying to steer you in the wrong direction.
The problem is not that you have an addiction. The problem is that you haven't done anything about your addiction.
I'm trying to do something about it right now.
See, I don't know that because this thing's this long.
All right. Well, I'm asking you for a chance.
Which courts do you owe money to?
Painesville Municipal.
Who else?
That's it.
What about Bratnall?
No.
Chardon?
Nope.
Pay those all off?
Fines are all cleaned up everywhere.
How much you owe Painesville?
Approximately 1,800.
When's the last time you had a valid license?
June of 24.
Ms. Tuttle?
Thank you, Your Honor. As mentioned, the defendant has a 30-year criminal history. He has prior prison terms that he had served, and prison would certainly be appropriate here, but he also does have some gaps in his criminal history. If the court was inclined to order community control sanctions, the state would request that come with extensive residential treatment, such as JTP, NeoCap, and or inpatient residential treatment. The defendant does have 7 days of jail time credit, and we would ask for a forfeiture of the contraband and instrumentalities. Thank you.
Review the pre-sentence report, the drug and alcohol evaluation. I've considered all the provisions of 29, 29, 11, 12, and 13. I've listened to you, listened to counsel. I'll place you on community control for 5 years, 30 days in jail with credit for 7. Going to enter into either Lake House or Concord Pines. Complete the program, follow the recommendations. You're going to go to a sober living facility for a minimum of 6 months. 5 AA or NA meetings a week. And obtain a sponsor. Obtain and maintain full employment. Get a valid driver's license, complete the decision points program, pay the costs and supervision fees. Anything else, Ms. Randallson? You understand all the terms?
I do, sir.
If you don't comply with the terms, the state will file a motion to terminate your community control. If it finds you violated, it's 12 months in prison. You understand that?
I do, sir.
Now, one of the things you said to me is you're not bullshitting me. I guess we're going to find out right quick whether you are or you're not. Anything else, Ms. Tuttle?
The forfeiture, Your Honor.
Items subject to forfeiture are forfeited. Mr. Fatika.
No, thank you, Your Honor.
All right.
Hour 2 of TCF Live on this Tuesday. Good to have you all here. If it's blah, blah, blah. Let's talk properly, Dan. If this is your first time here, welcome. There we go. My talking abilities are apparently out of practice, having taken the long weekend. Got to work on that. So, anywho, couple things here real quick before we move on. Judge said or implied that you can't purchase a vehicle without a driver's license. That is 100% not true. What do you mean you can't hear me? Okay, it's just you, Austin. Everybody else seems to be able to hear me. Anyways, what I was trying to say, vehicle purchases. He says you can't make one without a driver's license. That is not true. I spent many, many years in the auto industry, and you can purchase one without a driver's license just fine. My audio is low. How's that? Is that any better? It looks fine where I'm at, but who knows? There. That's dialed up a little bit. Hopefully y'all like that better. Again, this is what happens when you take a long weekend. Everything gets messed up. Anyways, what I was trying to say is that it is 100% legal to purchase a car without a driver's license. It's just not legal to drive it. So there is that. Also, one of the things that I noted, this particular defendant was complaining about the idea of going to NeoCap, and that's not the first time we've heard that out of this court. A lot of people have said, don't send me to NeoCap, Judge. So I looked it up. NeoCap, a community-based corrections facility in Ohio designed to provide rehabilitation for felony offenders as an alternative to prison. The duration is generally about 6 months. They focus on cognitive behavioral therapies. They give mental health, psychiatric support, and work towards a GED if you need it. There is a work crew component. The residents there participate in supervised, unpaid community service daily for local government or nonprofit agencies. Visitation is strictly controlled, rather. You have $50 a week to spend on commissary. But interestingly, and this I suppose is not surprising because of the people who would leave a review, it gets a 2.1 on Google reviews. So not a highly sought after facility by those who need help. But I looked up the details on it because everybody who goes in front of it is like, please don't send me to NeoCap. Everybody says bad things about NeoCap. So I don't know. Anywho, let's move along. Judge Stevens, Texas.
Nice thing. Oh, it was nice. I'll tell you about it. No, we had a good time.
All right, on Anthony Taylor, Mr. Taylor, that's you?
Yes, ma'am. Oh, excuse me. Yes, sir.
That's okay. This looks like a dress, I know. You're charged seriously, though, with a third-degree felony.
of operating a motor vehicle while intoxicated, because you have 2 prior felon DWI convictions, every time you get caught, it's a 3rd-degree felony, and it'll keep adding up. And well, yeah, but you made a promise the first time back in '86 that you wouldn't get caught again doing that. So it was '86 you were convicted, and '96 you were convicted. Thank you, man. And then now you've got this charge, and it looks like the blood alcohol test showed that you were 3 times the legal limit, 3 times the legal limit for intoxication. This is a 4,000, 5,000 pound missile that we operate around town, and it has to be operated responsibly, soberly. And when you're doing this, you're just thinking about yourself and getting intoxicated. But too often we have people in here who we have to struggle with because of the emotion and the weeping and crying because their relatives were killed in a car wreck.
Yes.
And generally it's because of operating motor vehicles while intoxicated. So we're sensitive about it. So you're looking at up to 10 years in prison here. You know that. Oh, you know that. It's no less than 2 nor more than 10 years confinement in prison. Okay. Mr. Adams is here representing you. What are we going to do today?
Judge, I just wanted to move this from the initial setting to the announcement. I did download the discovery.
Okay.
Just one of my concerns with him is that he's 70-year-old man, and I do believe.
What's wrong with that?
Well, no, that's not bad. Yeah, I think that he's starting to.
It's very close. It's so sensitive.
No, I think that he's starting to show some of the earlier signs of dementia in talking with his family. I have 1, 2, 3, 4 of his siblings here with him today, and that's going to be one of the things that I kind of want to deal with.
What are we doing about right now?
Right now, he's not driving.
Is that right?
To my understanding, he's not.
You don't drive a vehicle. You're not. Okay. I'm not talking about just today, but okay. Then that's what we're going to do. Order you not to operate any motor vehicle unless this court approves it. Do you understand, sir? That means somebody else is going to have to drive you. So we're going to walk or ride a bike.
Yes.
Okay.
But that's an order of the court as a condition of your bond. If you get caught driving, even if you're not intoxicated, violating a bond means your bond can be revoked. And then you could sit this thing out in jail until we get down to resolving this one way or the other. But that's the safest thing. Somebody's going to have, until we can get this all worked out and smoothed out so that it's a safe environment for all of us, you cannot operate a motor vehicle. Do you understand? That's a condition of your bond, and it's on the record. And we'll alert the bondsman about that new condition.
And I think it's going to resolve with the judge.
All right. Get a resetting, then normal resetting. Thank you.
Just go right there. She's like, thank you, Judge. Let me get to Mr. Hugh.
I think you're busy this morning.
Oh, yeah.
Okay. Hey, Don.
Yes.
John Deal.
Yes, sir. He's here. John Deal.
Oh, it's DWI day. Looks like.
Right here.
Oh, yes.
Yeah, no, you're good. In the back, you're good.
What are you later?
All right, I'm looking at this whole indictment, and we've got some issues here too. 26 CR 376 is called Sean Keith Deal. Are you Mr. Deal?
Yes, sir.
Present with your attorney, Mr. Dusler, and the state's attorney. You have been indicted with as the same person here before you, there, Mr. Taylor, with a DWI third because you have a DWI conviction in 2002 of them.
If you have someone helping you out, you can get them.
2 of them in you were convicted on the same day, but two different cause numbers. I don't know what happened in 2015, but that wasn't a good year. So you pick up two DWIs, you were convicted of those. Now you've got another driving while intoxicated. This becomes a third-degree felony because of your two priors. It's no longer misdemeanors. These are now, every time you get a DWI, it's a felony. But it doesn't end there. You have a drug conviction back in 2004 in this court before I was here. So this would be normally a third-degree felony up to 10 years in prison. But because of that prior conviction, if it's proven true, you're convicted of this, you're looking at no less than no more than 20 years confinement in prison. 20 years. Do you understand what you're looking at? It's serious. It's more serious than the previous. Right? Because you have a prior felony conviction. It's on. What is it? Stop here. You too were 3 times the legal limit, 0.248. I mean, that's and you're driving around a 4,000-pound missile and you're out of your mind when you're at 2.248. What was this at 5 in the morning? Yeah. All right, what about you? Are you driving a motor vehicle? Who drove you up here?
Dropped off.
By whom?
Me.
Who is that?
Definitely.
Okay, what kind of car do they have?
Black building.
When are they picking you up?
Out. So
if I catch you operating a motor vehicle, okay, because that's one of the court's orders with you too. You can't operate a motor vehicle. If I find out you do, your bond's revoked and you'll sit out in jail until we can get this thing resolved. Because once again, this is 3:30 in the morning. You're drunk 3 times the limit, and and apparently you couldn't even understand what the police were asking you to do when they found you in the vehicle. So that was a dangerous situation. So you too have an order on your bond, and your bondsman will be notified that as a condition of bond, you cannot operate a motor vehicle. Somebody else is going to have to drive you around. Do you understand? Yeah, you got an interlock in there? Is that what you have? You put an interlock in there?
that's fine.
How does it work? Okay, but you didn't use it today? Why not? You're thinking. You're thinking. This doesn't make any sense. Why didn't you drive up here with the interlock today? If you have an interlock in here, why would you get somebody else to drive?
Because I didn't get the SRS from 2 years.
Oh, okay, well, you can't operate a motor vehicle without that. Why?
That's why I haven't been back.
Okay, when did you get the interlock in?
When I got out of jail, they said to get it within 30 days.
Or 4 or 5 months ago? That car's just sitting there?
February. Yeah, February.
Yeah, but you can't operate it without SR 22.
But it was a bond condition.
Again, I'm going to speak English slowly. You cannot operate a motor vehicle without the proper insurance.
And that's why I don't drive.
Why did you pay for an interlock device?
The bond condition, they said I had to have it within 30 days.
Oh, if you drive a car, are you driving that vehicle?
No, it's just sitting.
Yeah, I bet it's just sitting there. Well, you could be paying for a lawyer to get the lawyer not out of business because he's been appointed to represent you. But this doesn't make any sense. Why would you spend money on an interlock device if you're not going to drive your car?
Because I didn't know they broke the bond or not if I didn't get it.
All right. Okay. You're in the deep end of the pool and all you're doing is sinking. You need to fix that. But one of the things is you're bleeding money. But that's your business. That's not the way I would have handled it. That's not responsible behavior. We catch you operating a motor vehicle without the proper insurance and interlock device, then you will be placed in jail. And you're looking at up to 20 years in prison on this, so that doesn't look good. But if you're not going to operate your motor vehicle, why are you paying for an interlock? That just defies any logic. What's that costing you a month?
88. No, 88 plus 25 for the calibration, so 113.
Couldn't you use that money for something else if you're not going to drive the car?
Yes, of course.
Well, it's just an idea.
Do I get it removed?
That's what I would do. It's your business. It's your money. But it just doesn't make sense. All right. But make your choices. But nonetheless, follow the law, follow the rules. On my watch, you get caught fouling up when it's a DWI and you go to jail. That's what happens. Because it's too dangerous. You have too many people coming here weeping and crying who are victims, family of victims who were killed or injured because of irresponsible driving by alcohol induced drivers. And it's always a sad time. And I can't bring life back, but we certainly can prevent further mistakes. So you've run out of mistakes here. You're still acting irresponsibly. You need to fix that. You're going to put that on the announcement document. Get a resetting. Okay. Chester Farm. It's 26 CR 379. Don, talk. You need to help him understand
It's not
that that's just, you might as well just give your money away. Anybody wants free money? Yeah, everybody raise their hand. That's just, that's not a logical decision. 26 CR 379, you're Chester Farr. Yes, you're here with Mr. Dusler, your attorney, and you're charged with aggravated assault with a deadly weapon here. You have a prior conviction of aggravated assault out of Orange County. So if convicted of this second-degree felony, and if it was proven true that you have this prior conviction in 2006, this turns into a first-degree felony. You're looking at up to life imprisonment in this case. What are we going to do?
Reset for announcement documentary.
Also, if you're convicted because this is aggravated assault and it states that a deadly weapon was used, if you get imprisonment, you cannot get paroled until you serve 50% of your imprisonment. So if you get life, that's a long time. Or you're even paroled. Just once again, this looks like a mess that didn't need to happen. Nothing to do except Except, getting into a box cutter fight with others, with other people. Get a reset. Okay, Brian Garcia. Brian Garcia.
Wow, highlighted that correctly.
This is another DWI, third. Let's see. I don't have a blood specimen out of this probable cause. What would it end up being?
0.224.
Sir?
0.224.
It's 3 times the legal limit day today. Because you have 2 prior DWI convictions, you're looking at up to 10 years in prison. Do you understand?
Yes.
Okay. All right, what are we doing on this defendant? What are you doing about driving? Do you drive? Why not?
No, it's suspending my license.
They did. That means you can't operate a motor vehicle. Who brought you up here today?
My coworker.
And where are they?
No, they're out of the bus.
They're what?
They're out of the bus. They're just there, to call them different business. Pick me up later.
You're still living in Pasadena at 2212? Go ahead, Don.
Just requesting an announcement, Dr. John. He's got a good job firing. He's going to get somebody else.
You say something.
I said he's got a good job with the firing. He's going to get somebody hired by the.
Oh. Well, but you say, I thought you said he was going to get fired by the.
No, I'm sorry. Here.
That could happen. I'm with irresponsible behavior. That's, it's not fun. This is your 3rd DWI. You think it's funny? It's not. And especially this was a wreck, accident. Yeah. Well, that's ridiculous. And then again, 3 times the legal limit, which means you don't care about everybody else. You just care about you, which is irresponsible. So you financially get into a 4,000-pound missile and put everybody else at it, which is what it does now.
Yeah.
You have to be more responsible. I'm sorry. You have to start thinking about everybody else and they're not just you. Get a reset. Noah Neiman.
How did that morning go?
This is the third different county you've picked up a criminal charge in, right? Controlled substance conviction. out of San Jacinto County, controlled substance conviction out of Liberty County. Now, let's say theft of metal. Another state jail felony. So we've got 2 prior state felony convictions. What does that do?
33.
Yeah. So you're looking up to 10 years in prison now. You understand?
Yes, sir.
Okay. You don't seem too bothered.
Oh,
What are you doing about it?
so,
How are you going to handle this responsibly?
I would like, thank you for letting me take care of the business in Harris County. It's been about 9 months. I would ask the courts if I could have a couple months I'm not working. Let me get to work. I would like to hire an attorney.
You've had enough time. I mean, you were indicted, like you say.
I was
9 months ago.
incarcerated.
I don't care.
Okay, yes, sir.
You
No
know,
problem.
yeah, my best advice to you is don't commit crimes.
Right.
We don't have those. Everybody's got a problem on that, but we move forward. We don't wait on you.
Yes, sir.
We got to move forward. And
Well, I'm
fortunately, our public defenders are responsible people, and they handle something responsibly. They handle things responsibly here. And in fact, Don's been an attorney longer than me. And
Mr. Dusler?
that man, yeah. And you can hire anybody you want, though,
Right.
anytime.
Well, Mr. Dusler's kind of passed judgment and said it was a slam dunk case on the prosecutor's side. And
He's there to give you advice, but he's gonna, if you want to trial, he tries it. And he will represent you, but
Can I have any time to try to get myself together for an attorney?
but you were indicted back in July of last year.
I've literally
This
been
is
out
May, June,
28
we're
days.
almost a year. We're moving forward. You want us, yeah, if y'all can't resolve it.
Want to go to the announcement docket, Judge. He's just gotten out of rehab, and I think give him an opportunity to hire somebody who's trying to do that. Just a regular announcement docket. What's your name?
Noah Martin Niemeyer.
You were in the substance abuse treatment facility?
Yes, sir.
Why?
So because I give a dirty UA. Yes, sir. To adjudicated probation out of Harris County to my probation officer. Yes, sir. I am clean now. Will stay clean.
You were supposed to stay clean before, right?
Right. And prior to me going to the subject of. You want to finish?
I'm listening. I can multitask. Go ahead. I'm not sure you can.
Prior to the substance, I was in Harris County jail for 3 months. And a lot of that was behind this case that I acquired with my deferred adjudicated probation in Harris County. I'm fighting 2 entities.
This doesn't say you have to defer. This says it's adjudicated.
I thought
that means the final, you were convicted and you're placed on regular probation.
This is something new that doesn't show up in the indictment.
No, sir. I am on deferred adjudicated. I promise you. I am on.
Are you on regular probation?
No, sir.
It says
adjudicated.
Okay. Our client, this is professional bond. Our client is set to court tomorrow in cause number 25, which is this one. However, he is currently incarcerated in Harris County since August. Harris County reinstated his adjudicated probation, which will be finished by February 2027.
Yes, sir.
That's incorrect.
That's adjudicated means it's a final conviction. It's regular probation. Unadjudicated means deferred.
So
I've been doing this a long time, and this is, we're simple. But you're just missing the semantics. You don't understand the terminology and.
Well, maybe I did, Your Honor.
But are you on final, tell me the truth. Are you on deferred or unadjudicated probation?
I am on the type of probation where if I complete successfully, I can get the charge off of my record. That's
That
what I
can
tell
happen
you for sure.
that can also happen in regular probation.
Looking up on there, it's
But
like, it's deferred.
it's deferred, okay.
I'm sorry, Your Honor.
I don't know why, I'm just reading something from your bonding company that calls it adjudicated. They're clearly stating adjudicated probation, which is a
Apologize.
conviction. But your indictment shows at least 2 other convictions back in 2011 and 2016.
I understand.
Okay.
Judge, I'm looking at the Harris County website and it is deferred.
Yeah, they need, you might want to, they're sending things out, calling it adjudicated, which is, if that's wrong, that's a big difference.
Yes, sir.
It makes a big difference, especially
What
when
can
the
I do
court
for
reads
you?
it. You might want to get with them and correct them, since you're paying for them. You're paying them. So you want to put on announcements, what you're doing. Get a resetting. Thank you. Okay.
Thank you, Your Honor.
Yes.
Now in hour 3 of TCF Live on this Tuesday, where we're still trying to knock the rust off here in the bunker. It's amazing. You take a few days off and you forget how to do some things. But I'm working on it. Let's stay in Texas, but keep our promise of 9 to 11% more Judge Boyd. Here's Judge Boyd.
And I accidentally X on the line saying I recommend the third way and community supervision. Okay, sure. Not on the second row. You have a case in here?
You're welcome. All right, court is calling 2026 CR 001115, State versus Demontre. Renee Gaines, can I have parties announced?
Robert Brobach for Gaines.
And are you Mr. Gaines? Counsel, have you received all discovery that you reviewed with your client?
Yes, ma'am, I have.
Court will find that the state is in compliance with discovery. Mr. Gaines, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it? Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, ma'am, I did.
State, are you proceeding on the indictment as presented?
You're proceeding on paragraph B. Judge, count one, you can vote for their paragraph.
Any objections to the waivers?
No objection, Your Honor.
Mr. Gaines, did you review the court admonishments with your attorney? Did you understand it and cite it in all the appropriate places? You're charged with the offense of collision involving injury. That's a hybrid case. So the range of punishment is a possible fine up to $5,000 and imprisonment not more than 5 years. If you have a plea with the state, or confinement in the Bexar County Jail for not more than 1 year. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand that the court would grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could sentence you to the full range of punishment. Counsel, has your client been able to provide you with any defenses?
Yes, ma'am, he is.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, ma'am, he is.
Mr. Gaines, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on paragraph B under count 1. Punishment is to be assessed at 4 years in the prison. There's a $1,000 fine. The state is silent on your application for deferred adjudication. They are recommending community supervision, and there's to be restitution to the complainant, if any. Did you understand that to be your plea?
Yes, ma'am.
State defense?
Yes, ma'am.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Any such motions?
No, ma'am.
Outside the agreement, the state is recommending that your community supervision be for a term of 4 years. There be a TAP evaluation, 120 hours of community service restitution, no contact with the complainant, MRT, and driver safety course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense in count 1, paragraph B, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Without receipt, exhibit 1 and all attached.
No objection, Your Honor.
All right, state, you may be excused. Thank you. All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding you guilty as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, we are, Your Honor.
All right, anything you wish to say on behalf of your client?
Yes, Your Honor, the defendant has no criminal history. He works full-time at Jim's restaurant. He's already taken his driver's courses, his anger management courses. He's been here every time. He's always on time. He'll follow your rules. I think he'll do well on probation.
So how old are you?
I'm 28.
All right. So here's the thing. I don't understand why people leave a scene when they're involved in an accident, because guess what? Even if you don't have insurance, that's potentially a misdemeanor. But when you leave the scene of an accident, that's a felony. All right. So, do you have insurance for your vehicle?
I had insurance at the time, and yeah, all my stuff was up to date. I had penance at the time, and it honestly caused huge impact on me and everybody around me. So like, I'm really sorry that I ran from the scene when I should have stayed.
Yeah, because I mean, anything could have happened. The other person could have ended up dying, you know? You know, I see a lot of times people panic, and it's like, take a deep breath and think, what's the right thing to do, you know? All right. Bashan, are you ready? All right, this is what the court is going to do. The court is going to sentence you to 3 years deferred adjudication. I'm sorry, what did you say he completed?
He completed his driver's ed courses.
Okay.
Completed anger management. He started on some community service.
Okay, Vashan, 2 years deferred adjudication, regular reporting by Zoom or in person, regular UAs or the patch, proof of employment within 30 days, no employment as a home health care provider or with minors, field visits 1 time per month for 2 months, $1,000 fine, that will be probated. Do you know if your insurance paid?
I know that they gave her the max amount of the liability thing.
They paid her 30,000.
All right, so there'll be a restitution hearing. Normally, can I have a restitution hearing in 30 days? June 25th. All right, restitution hearing June 25th. Do you have any children?
I'll have one.
What is her age?
First 3.
Okay. 120 hours of community service restitution. Once he completes parenting classes, that will be deemed satisfied. And you've already done the driver safety course? All right, I'm going to order the driver safety course. You need to provide proof of that to probation within 30 days. And you say you have insurance as well?
I had insurance, yes, but I have, because I don't have my car no more, but I still have the information that was done when everything happened.
All right, there's to be no driving until proof of liability insurance. And so if you're driving somebody else's vehicle, then they'll need to have you on there or have that anybody can drive.
So once I have a liability insurance, I can drive again.
Yes, but you need to turn that into probation. So you need proof of liability insurance and a valid driver's license.
The one I have is going to be revoked, right?
No.
That's correct.
Probation, is there anything else? Is there anything else you need from the court in order to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? All right. just make sure you provide all that information to probation about the classes that you've done and also about the liability insurance. And Norm, if you can give them a reset, we're going to have that restitution hearing on June 25th. You can appear by Zoom. All right. All right. Good luck to you.
Okay, thank you very much. Thank you, Judge.
You're welcome.
Hour 3 of TCF Live. So Austin asked a question about why is it that Texas judges often excuse the state partway through. So according to the Texas procedural rules, the judge has the discretion to excuse the state partway through a sentencing hearing if the defense and the state have a pre-existing plea bargain agreement in place and the state has no further interest in the proceedings. In other words, they've said what they need to say and there's nothing more that they're going to add. So that is why that happens there. Something else I'd like to point out. So during this hearing, there was a long pause as Judge Boyd was reviewing some of the information before she gave her sentence. This is the reason why you may want to consider the TCF podcast, especially if you need to catch up on things you've missed during the live show here. On the podcast side, we remove all of those pauses and make it for a very quick listen. So you can find that over at Apple, Spotify, or wherever you get your podcasts. It's a great follow-up for the show, again, especially if you're in and out and you're missing things. So be sure to check that out. And while you're there, if your podcast platform of choice allows for it, please do consider leaving a review. That helps the show get found. Okie dokie, let's stay in Texas, but let's go say good morning to Judge West.
This is 26 DCCR 0744. It looks like Mr. Adams is charged with aggravated assault with a deadly weapon, and Mr. Rojas has filed a motion asking that I reduce the bond currently set at $150,000. Is that correct?
That's correct, Your Honor.
Mr. Adams, the best you can, raise your right hand, please, sir. Do you swear?
Oh, yeah.
Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead, Mr. Rojas.
Jim, how old are you? 21. Where are you originally from? Houston. Okay, but when this incident happened, you were living here in town with your dad? Yes, sir. And your dad's the victim of this, is complaining witness in this case, right? Yes, sir. Okay. How long have you been in jail? Since April 8th. And the only other person other than your father that can realistically help you with this is your mom, right? Yes, sir. Okay, and your mom, you've talked with her and you've talked to her, she's unable to make a bond of $150,000. No, sir. Okay. Do you own any property that you could sell, a house, a car, a land? Do you have a bank account in your name? Yes, sir. Do you know approximately how much money is in that account? Probably zero, maybe in the negative. Okay. This is, again, you're 17 years old. This is the very first time you've been arrested, right? Yes, sir. Okay. Your mom's gonna help you out with the bond if we can get it lowered, and I think maybe an aunt, he said maybe there's an aunt out there that can help her. Okay. Are you married? No, sir. Do you have any kids? No, sir. Okay, so it's just you. Just me. So if you're able to make a bond, like I said, before this, you were living with your dad. What's your plan? If the judge will let you, you want to go live with your mom in Austin?
Yeah, so I will go to Austin. I already have a job lined up for myself. She's holding it down for me right now. She's also working to get her own apartment so that I can go move in with her, then I can start working and continue back on my plan to get back in school.
Okay, and you say get back in school, but was that high school?
No.
Okay, where were you going to college at?
Probably did relate to university. It's in San Antonio.
Okay. And once you're able to get this all behind you, that's your plan to get back into college?
Yes.
All right. That's what it's doing.
Just so we're clear, you're 21 years old, right? Not 17. I think that was a misstatement.
Yes,
Okay.
21, yes.
Apologize. Did I say that?
I think you said 17. I know it's an error.
Right.
I have another question, George.
Okay. Any other witnesses?
No, Judge.
Mr. Nichols, what's the state's position?
Judge, he's accused of breaking into his own home after he'd been kicked out, and his father tried to push him out the window that he broke in through. He grabbed a knife and stabbed him. I think 150 is appropriate in this situation, Judge.
And for the record, I am taking judicial notice of the court's file. It includes the probable cause affidavit. If you'll give me just a second, let me So you said you would be going to Austin if you make bond, no matter what that is, and living with your mom, is that correct?
Yes.
But that she would be getting her own place. Where does she live now?
I believe it's one of those homes where she's pays for that space.
Okay.
I believe the money she's paying there, she can also pay for an apartment. So that's what she's doing while working both jobs.
And what's the job that you would have?
I would have the IHOP job. That's her second job. That's the job that I will be going to.
When's the last time you were in school?
I believe in May of 2024. That's when I left college. I can keep up the $40,000.
Speak up.
I said I cannot keep up the $40,000 on my own for tuition.
Any history that you can?
Minor juvenile, I think an arrest and a non-suit out of Harris County for burglary within the juvenile, but nothing else, right?
All right, so what I'm gonna do, Mr. Adams, I'm going to grant the motion. I'm going to reduce your bond for $100,000. Condition of that bond, if you make it, is going to be that you obviously have absolutely no contact, no communication with David Keys. You will be ordered to wear a GPS monitoring device. You will be allowed to live in Austin with your mom. You would have to get that address before you go to your attorney or to your bondsman. And also obviously not be anywhere near the residence at 1970 Ave Street. You understand?
Yes, ma'am.
No contact and no communication means none. That not sending messages obviously means in person, but it also means sending any type of messages yourself or through anybody else or anything like that. You understand?
Yes, ma'am. I have no intentions.
And then we set it for an announcement. All right, you can go back with the bailiff.
Thank you.
Thank you.
Alrighty, friends, let's change it up. Let's go back to Judge O'Donnell in Lake County, Ohio. Looks like he has a new contestant.
Your Honor. Your Honor, before you this morning is the matter of the State of Ohio versus Santez Tucker. It's case number 26 CR 270. The defendant is present in the courtroom with his attorney, Nicolette Tomaszek. Before the court for purposes of sentencing, the defendant having pleaded guilty and being found guilty of 1 count, F4 assault. Parties are ready to go forward, Your Honor.
All right, thank you. Ms. Tomaszek?
Yes, thank you, Your Honor. We would like to ask the court today to give Mr. Tucker an opportunity on community control sanctions. Your Honor, in speaking with Mr. Tucker, he has had an opportunity to meet with Larry Heller from NORA. It is something he's very interested in. There is a bed available for him. I do understand that Mr. Tucker also does have a holder out of Cuyahoga County currently for a warrant. Our office has been in contact with his probation officer there, and the intention is to have Mr. Tucker on their mental health docket. From the start of this case, Your Honor, up until now.
What's the warrant for? Anybody know?
I believe it's in the PSR, Your Honor. It was a failure to appear. Okay.
I believe it was for an F3 tampering and F4 theft.
The warrant's on his failure to appear on his probation. Is that right?
Oh, yes, sorry. He did the CBCF through Cleveland, successfully completed that, but did not appear to probation after completing the CBCF.
All right.
Yeah.
Okay. All right. Yeah, he failed to report to probation since his release from the county jail on February 21st, 2026. And then he was booked into Lake County Jail on this case, and he's been here since. So I know they do have a holder. We've been in contact with probation out there, just because Mr. Tucker did successfully complete the CBCF. So they do want to have him on the mental health docket. from the start of this case to now, you know, Mr. Tucker did definitely present some mental health issues. I understand he was on a very high dosage of medication. He has since been on the correct medication to jail. So he's getting that under control. Mr. Tucker has also been very upfront and honest about his drug use. He knows he has an issue. He knows he needs to get that resolved, so I do believe, and he believes that Nora would be a good fit for him. So we'd just like to ask the court today for an opportunity to place him on community control, allow him to go to Nora, and allow him an opportunity on the mental health docket in Cuyahoga County. Thank you.
Okay, Mr. Tucker, what do you want to tell me?
What I went through was really unjust, and I just wanted help, and this treatment facility is not a high drug traffic area, and I have constant back pain from getting police brutalized. I don't want to say that it's a hate crime.
Back pain from what?
Police brutalized, and even in the county, this county jail, I've been neglected by CO, so I really don't wish to speak anymore. I just want rehab, honestly. I suffer from 13 years of crack cocaine addiction and have taxes to pay, family members, gas, utility, and such forth.
So you don't want to, you said you don't want to get into what happened. Either
it was just
this or at the jail. Is that right?
Oh, both parties. That like racial discrepancy, but I just want help. I'm tired of using, and this is a good treatment facility for me.
Well, that's a matter of opinion, quite frankly, but you're very violent.
Can be not.
You are. I mean, your past indicates you're violent.
Correct.
You were violent this night. You've been causing constant problems in the jail. You know, talking about getting the guards, or I forget the exact words you said, but there's no getting past the fact that you're violent, and it's probably rooted partly in your, well, I think it's probably three parts. You're violent, you've got mental illness, and you like drugs. And you put all those things together, and you're fighting with the cops in Painesville for no reason. No reason.
He had a gun. I didn't.
What?
They had firearms. I didn't.
Yeah, well, they didn't point a gun at you.
Yes, they
Okay,
did.
one guy had a taser out, and he didn't use the taser. Okay.
That's because
And now, when I read this report, he should have used the taser. That would have probably alleviated a lot of the problem. But they didn't go to the extent of using the taser.
That's because my friend's mother, whose car I stole, she's 1,000 pounds, and she was yelling. And Mauser, the same size as me, stopped the little cop from shooting me.
Cop wasn't going to shoot you. Didn't have his gun out.
And then it was a dog on the scene. All I remember, honestly, from my standpoint, is a woman of 1,000 pounds yelling, "Stop, get off of him." And I have asthma, and they cracked my head on my skull on the side of the ground and my teeth. I have nothing else to say.
And yet you elbowed him right in the face.
That's self-defense.
Well, maybe we should have a trial. Are you telling me you didn't assault the police officer? Because you pled guilty to assaulting the police officer.
Yes.
Are you telling me you didn't assault the police officer?
I'm not saying that at all.
Okay. Who's Trina Bentley?
Who is Trina Bentley?
Who's Trina Bentley?
That's my auntie.
Why did you tell her, why did you say to her, "I'm about to fuck these guards up again"?
Because people in there were fraternizing with me. Like, those messages you're reading wouldn't even make sense to you.
I don't know. You want to help me make it make sense that I'm about to fuck these guards up again?
That's
Yeah.
every time I got neglected and beat up.
Beat up by who?
Certain CEOs that are racist.
Okay. Okay, anything else you want to say?
No.
Mr. DePiero?
Your Honor, the state position is the defendant is not amenable to community control. This is the second time that he's convicted of assault on a police officer while he's on felony probation. The first time was in 2019. Judge Michael Shaughnessy, who was on probation for an F2 robbery back then, got 2 years of probation, and then less than a year into it, he gets convicted of an F4 assault on a police officer. Judge Shaughnessy sent him to prison for 2 years. One of those years was for the assault on a police officer concurrent to the 2 years, but that must not have been enough, because here we are again. So the state recommends prison because you can't hit cops, you can't assault cops, and there's got to be a punishment for that. Thank you.
Thank you. All right, I've reviewed the pre-sentence report, the psych report. Didn't receive any victim impact statement. And I have considered what Mr. Tucker has said, what counsel have both said, considered all the provisions in 2920 and 11, 12, and 13. Your record as an adult starts when you turned 18. Drug abuse, misdemeanor, disorderly conduct, misdemeanor, criminal trespass, misdemeanor, attempted assault, misdemeanor, domestic violence, assault, endangering children, misdemeanors, obstructing official business, misdemeanors. 2018, F2 robbery and F5 drug possession. Sent to prison, got out in October of 23, so spent almost 4 years in prison. That was after violating probation. So while you were on probation, you got an obstructing official business misdemeanor, assault with a police officer, felony 4 and 19. That's when you went to prison. October 5th of 23 is when you get out. May of 24, got a felony tampering with evidence, felony 4 aggravated theft in Cuyahoga County. Placed on probation, violate probation. And then while you're on probation, you pick up this assault, felony 4. And clearly, the officers dealt with you verbally. One took out his taser, was, as I said, probably should have used it, but didn't. You created the fight. You started the fight. 2 of these guys rolling around with you, trying to get you under control. And you elbow one right in the eye. Over since you've been at the jail, March 13, March 16, March 18, March 31, April 7, April 13th, April 15th, April 17th, April 30th, May 5th. All incidents with you. So, as I said, Mr. Tucker, you're a violent person. You haven't done anything to curtail that violence. You have no intention of curtailing your drug addiction because you like it apparently, and you got mental health problems. So you are not amenable to community control based on everything I just indicated out of the pre-sentence report, including your previous time in prison. So I'm going to sentence you to 18 months in prison with credit for 95 days, and the costs are assessed. When you get out, you might be on post-release control for up to 2 years under the parole authority with conditions. If you violate the conditions, the parole authority could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. If that violation is a new felony, you could get an additional consecutive prison sentence for the violation, the maximum of which would be the greater of 12 months or the time left under post-release control. Anything else? Remaining charges are dismissed. Anything else, Mr. DePiero?
No, Your Honor. Thank you.
Ms. Thomasek?
No, Your Honor, thank you.
Now solidly in our last half hour of TCF Live this morning. It's good to have you all here. I think there's some new friends out there. Again, as I said earlier today, if you are new to TCF, do take a moment and say good morning to us in the chat. We'd love to hear from you. Reminder tonight, Sidebar, 8 p.m. Eastern, 5 p.m. Pacific, right here on this channel. If you like TCF Live in the morning, you'll love Sidebar in the evening. That is community driven. That show was not my idea. It was the idea of members of the community, and several of us get together and we discuss various legal topics and cases. Tonight, we're going to dig into the idea of taking a plea deal, but then kind of denying the facts and the responsibility of it. We touched on this kind of in the last sidebar that we did, but that was very defendant specific. I think we're going to have a broader discussion on the matter tonight. So do join us 8 p.m. Eastern, 5 p.m. Pacific. Let's go back to Judge Boyd.
And to the clerk,
Yes.
I don't have the docket sheet for 2025 CR 013253. I have 2 printouts of the same. All right, the court is calling 2025 CR 013253 and 2026 CR 003891, State versus Jose Calderon. Can I have parties announced?
I can go away to the state.
Carlos Martinez for the defendant.
All right, and are you Mr. Calderon?
No.
You entered a plea and the cause number ending in 53. You entered a plea to aggravated robbery according to your plea bargain agreement. Punishments be assessed at a cap of 8 years in the prison. There's a $2,000 fine. The state opposes your application for deferred adjudication. It's the run concurrent with 2026 CR 003891. In that cause number, you're charged with unlawful possession of a firearm by a felon. According to your agreement, cap of 8 years in the prison, $2,000 fine. State is opposed to your applications for community supervision and deferred adjudication, and the cases are to run concurrently. And each cause number, counsel, have you all received the PSI and TAP evaluation?
Yes, we have you.
All right, any objections?
None, young.
All right, state, do you have any witnesses?
You're good, sir.
Defense, any witnesses?
None, young.
All right, then the court will hear arguments. State.
Good. Or asking for you to deny the defendant's application and find him guilty and sentence him to the 8 years in prison. That is based upon the stipulated evidence. And so in review of the PSI, it seems that the defendant is of the opinion that they because and so I take issues based on what was stipulated to the defendant was the driver. So I will stipulate that he's not the individual that got out of the car and brandished the gun to the complainant. However, he was the driver and passenger. is the one that got out and did that. And so taking those things into consideration in the plea bargaining process, that's like state finally used to waive the punishment enhancements, and we were able to reach the agreement we did. However, based on his history and facts in the case, we are asking friends.
All right, just one moment, off the record for a second. This is for Eric Mason. That's okay. Hey, it's okay. All right. Hey, it's a Monday. Yes,
Okay.
we're good.
Okay.
And I can just put it in the system. All right, counsel?
It's like a Monday.
Yes.
Judge, as we know from the PSI, Judge, defendant has been out of trouble for almost 10 years. Now, this is a very serious offense, and of course, my client, perhaps he misunderstood the PSI officer. He meant to say that he was not the one that did the robbery, that he was sitting there. They were through a drive-through ordering, and supposedly his passenger got off and committed this robbery. They could never locate him, but he completely understands the law parties. When he first came to me, even before he got indicted, he wanted to know, do you think that I'm going to have a problem? And of course, I told him back then, yes, you probably will. I said, because the law parties, if you're there and if you took off on the vehicle, then we're going to have a problem. And sure enough, but he takes responsibility. He's here, he put out, Judge, and as you probably knows from the PSI, he's responsible for 4 individuals, actually five with a wife. But there's some stepchildren involved, and then there's 2 of his, and he makes good money. He does concrete work, finisher, and they verified it that he makes around $4,000 a month. So we're hoping that the court would consider, Judge, giving him another shot. If not, if we would consider the lower end of the cap, only because, just like I said, he understands the law parties, he understands he was with him, and that's why we find ourselves in front of you, Judge.
Does your client wish to say anything or no?
No, Judge, we've discussed that in detail, and he wanted me to speak for him.
All right, Mr. Calderon, I want you to know that I have taken everything in consideration. I always keep an open mind about everything because sometimes things happen. And there's sometimes things happen and people are not expecting them to happen, and then everybody just gets caught up in the circumstances. But I don't think you're a good candidate for probation. So I'm not going to grant your application. Your attorney has spoken on what he's requesting. And I'm assuming the state is requesting the full 8 years. All right. And state you may be excused. Thank you. All right. And cause number 2025 CR 013253. Is there going to be objection? The complainant is saying he wants $50 for his wallet. That was
None, Judge.
all right. All right. And I want you to know, I'm taking in consideration that you didn't have the weapon and that caused them. The court is going to sentence you to a $2,000 fine. Time and money will run concurrently. This will run concurrent with 2026 CR 003891. There's to be restitution of $50 to Matthew O'Bara. There's an affirmative finding of a deadly weapon. And the court will sentence you to 6 years in the prison. Give you credit for any time served. And in that cause number that you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney, did you understand it and sign it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. In 2026 CR 003891. In that case, what happened with the weapon? Is it destroyed or not destroyed?
That I know of, I have not seen anything that says it got destroyed, Judge, but we have no evidence. That's what we're just, yeah.
All right. State destruction of the weapon or no? I don't know where it is. All right, and that cause number $2,000 fine, time and money to run concurrently. Destruction of the weapon is to run concurrent with 2025 CR 013253. And I read your statement in the police report, and I can understand how sometimes people are confused over anniversary dates as it relates to weapon. And that cause number, I'll sentence you to 3 years in the prison, give you credit for any time served. And that cause number, did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. You're welcome.
Okay, proceed.
Oh,
Alrighty, friends, we'll stay in Texas, but let's go over to Judge West, and we'll probably finish our day there.
Arnold,
Yes, ma'am.
and will your client waive the formal reading of the indictment?
Here we go.
Mr. Arnold, in cause number 26 DCCR 0488, you're charged with the third-degree felony offense of harassment of a public servant from January 30th January 30th of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Arnold is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of harassment of a public servant. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows this was an agreement that I followed, so you did waive your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Do you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts? You can talk to Mr. Rojas. All right, good luck to you, sir. You go back with the bailiff.
Yeah, go.
Bethany Batten.
Morning, Judge.
Good morning.
Yeah, it's great. Anytime somebody can get to the hospital, I'm not opposed. I think she does. Well, she should have it. When she did.
Good morning. You're Bethany Batten. Yes, ma'am. And this is cause number 24 DCCR 2349. I am going to take judicial notice of the court's file. I think we've already gone through this, but just to make sure the record clear, Ms. Batten was previously found not competent to stand trial, sent to the John Dunn Behavioral Science Center for competency restoration, was sent back here. It looks like we got a report April 3rd of 2026 that Ms. Batten was now currently competent to stand trial. Any other issues with regard to competency?
No, Your Honor, not from the state.
All right, then I'll make that finding that she is competent to stand trial. Will she waive the formal reading of the indictment?
She will, Your Honor.
Ms. Batten, you're charged with the 3rd-degree felony offense of assault on a security officer, and that's from November 14th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And you understand if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. All right, Ms. Batten, I'm going to find that you entered your plea of guilty freely and voluntarily. I find again that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of assault on a security officer. Sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to me, ma'am. You can go back to the bailiff.
Okie dokie, friends, that is it for this morning. I hope you all enjoyed it. I did. Thank you for bearing with me during a couple spots where I had to knock the rust off because it's been a few days. But I think overall we had some fun today. Appreciate all of you. Look forward to seeing you all tonight for Sidebar, 8 p.m. Eastern, 5 p.m. Pacific. So do please join us for that. And of course, we'll be back tomorrow morning, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour earlier if you're a channel member. Go have yourselves a great day. Look forward to seeing you all soon. Take care. God bless.